session on the important role of judges in stepping in the face of perceived or actual government inaction. So Justice Shah, please, over to you.
Thank you, Andy. That's been very kind. Thanks for all the praise. Ladies and gentlemen, I bring you good news today. I bring you stories of hope and promise. And I say that judges of the world and the courts of the world have united today. As you can see, they're all here. And judges of the world have now joined the climate change dialogue. And climate action, I assure you, ladies and gentlemen, will have a new meaning now as judges have come into the equation. Why judges? You see, politicians, as echoed earlier by my friend Chief Justice Barroso, politicians might be subject to some legislation, the Constitution and the human rights, and that's what we use to proceed further. So when we say that, the judges have over the past couple of years produced some robust jurisprudence across the globe. I come from a developing country. My jurisprudence is a bit different. My jurisprudence is adaptive jurisprudence as opposed to mitigational jurisprudence of the West. In my country, adaptation is the issue. Emissions is not my problem. Adaptation is my problem. So I am faced with situations of extreme weather, floods, drought. I have to look at urban planning in a different manner. So the challenges are totally different from a judge coming from a developing country. And I want to highlight that there are two different sets of jurisprudence in the world. One deals with mitigation, the other deals with adaptation. I deal with adaptive jurisprudence. And we have pushed the government to take steps, you see. A number of cases, Lagari case mentioned by Andy earlier, was where a government had a climate change policy lying on the shelf for several years, and the courts interfered and said, go ahead, do something about it. And the court's interference helped the government move 60% of that policy. Other cases where we've been taking a very climate resilient approach towards issues. For example, a cement plant was being set up in a water scarce area, and we shut it down. We said, no, it's not a climate resilient act because it's already a water scarce area, and cement plants are water guzzlers. In another case, we said, go ahead, any urban development that takes place in the cities of Pakistan will have a climate resilient approach. So everything we now look at, the statutes or the policies are with a climate lens in order so the government or any other actor that is participating in development to have a climate resilient approach. So there have been innovations, years and years for legislation to bring soft law into hard law, whereas one judgment can turn a soft law into a hard law, and that's what we've done. We've brought in precautionary principle as a hard law in our country. We've brought in public trust doctrine as a hard law in our country. We've brought in amazing concepts like in dubio pro natura, in dubio pro aqua. These were soft concepts. We brought them down as hard laws through our recognizing them through our judgments. We brought water justice into the debate. We brought climate democracy as a concept through our judgments. We brought intergenerational responsibility into the debate as hard law of the country. So that's what judges do, that's what judgments do. We've also brought in now, and I want to underline this aspect, very important, that various religions and cultures have a very deep-rooted attachment to climate and nature. And for example, I come from an Islamic country, and I bring in Islamic environmentalism into the debate. My religion tells me that I'm a steward on this earth. I am a Khalifa. I'm supposed to look after the earth. I have to maintain mizan, which is balance. And I tell you, several other religions, you pick up the text, will give you the same. So it's not as if this is new science that we're talking about. Our culture, our religions have talked about this. They're very deep-rooted, and we need to bring that and bring that into our judgments. We have also, you see, judges have now moved on from the human perspective of looking at the world and bringing in more biocentric approach towards things. You see, we need to move beyond humans. It's not about us. It's about nature, and we need to move in that direction. We need to understand that we have to protect the dignity of nature, and by protecting the dignity of nature, we're going to be protecting ourselves. We need to move beyond humans, please. We need to start respecting nature, and that will result in its own manner, and we'll reap benefits of that. We've also started looking at interpretation of laws and policies with a climate lens. We look at taxing statute and we say, let's look at a taxing statute with a climate resilience lens. Should this relief be given in a taxing statute to a particular party? We look at the laws with that. So the future that holds for us is that we need to move ahead and understand, for us judges to understand science. We champion judges alone. We need to have a mainstream set of judges all talking about climate change. Climate change is not a fancy subject where some champion judges are going to go give judgments. Every judge in every court must attend to climate change as the pivotal and perhaps the most important area of that court. And lastly, I would like to say that it's high time that we think of a climate global court. We need to have a global climate court, and the best way is to connect it with the Supreme Courts of the world so the enforcement is not an issue anymore. Every Supreme Court of the world gets connected to a global climate court, and enforcement is not an issue. So that's all I wanted to say, gentlemen, and ladies and gentlemen, good luck to you all.